President, successive chairmen and legal advisors have seen the need to amend the law. This has not been done. I learned that they are making representation for the amendment to the 1981 law. A number of lawyers fully agree that this law must be amended as a matter of urgency, not later, but now. Consequently, to save the taxpayers' money, and in the true Morsican tradition of molding a nation through service, I humbly offer free advice to the government. I recommend that the government follow the precedent in Barbados mutual funds law, and which mandates secrecy and prohibits disclosure of information. But unlike our law, it allows for exceptions. So Section 50 of the Barbados Act provides that prohibition against disclosure of information shall not apply to a disclosure that is lawfully required or permitted by a court or permitted or authorized by any other act. Information about the unit holder's account is required under the Mental Health Act and the Wills and Probate and Administration of Estate Act. On behalf of my clients, the many lawyers who are exasperated and their clients who are suffering, I call on government to make the necessary amendments to the Unit Trust Act as a matter of urgency.
No change to the Unit Trust Corporation or UTC Act is required to address the Senator's concern. As it relates to the mentally ill, the concern arises from the Mental Health Act, or MHA. There is a process under the MHA by which family members are permitted to access the funds of persons with a mental incapacity, such as Alzheimer's or dementia. That process is applied across all financial institutions, including banks, credit unions, and the UTC. Any additional access to information or funds may only be granted if the MHA is amended to allow for such information or funds to be accessed. Mr. Vice President, as it relates to deceased unit holders, the UTC Act, or Section 40, subsection 2, restricts the UTC from disclosing information to, I quote, to any person not legally entitled thereto of any information relating to the affairs of any person having any dealings with the trust, unquote. As a result, the UTC does not permit the disclosure of unit holder information to applicants for letters of administration following the death of the unit holder. Information is provided to the executors appointed by unit holders in their last will and testament.